Good morning, everybody. We're about ready to get started here. Nice to at least see everybody virtually. Wish we could do this in person, but it's one of those times where we can't. So I'm glad we can at least connect this way and connect with everybody. It'll be fun sometime to see folks back in our office for one of our morning seminars, but this will have to suffice for now. Want to introduce myself. I'm Randy Sutton, partner here at Saalfeld Griggs. And with me are my two partners, David Briggs and Jennifer Paul. And we're going to spend about an hour or so going over, reopening issues and kind of getting everybody oriented. So go ahead and let's go to the next slide, Sarah. We got our associate, Sarah Holmes, that's in the background. She's going to be our slide presenter. So anyway, so the three big topics we're going to talk about, we're going to go through best practices and kind of the safety issues, and Jennifer's going to talk about that. David's going to talk about managing employee return issues and the folks who aren't so excited about coming back from the extra unemployment benefits they've gotten. So he'll go over that, and then I'll talk about the fun world of acronyms, FFCRA, DOL, IRS, and all those fun things, FMLA, etc. So we'll wrap it up with that. As we go, be sure to ask questions, and we'll review the questions as we're going. Some of them we'll weigh in on as we go, and others we'll save for the end. And with that, Jennifer, you want to take it away?
Yeah, sounds good. Thanks, Randy. Happy, as Randy said, I'm Jennifer Paul. Happy to be here and presenting with all of you. So my topic today is talking about best practices for reopening and really focusing on this desire that we all have to get back to business as usual with mitigating some of the risks and really employers' obligations to provide a safe and healthy work environment for their employees. So let's get started. Sarah, if you could go to the next slide. Great. So kind of just taking a step back and thinking a little bit about where we are now. You know, for some of us, we've been away from the office for more than 3 months, or their offices have been closed, or you've just had a kind of a skeleton crew at the office or the work site, and we're thinking now about coming back. In Oregon, most of our counties are in phase 2, and Multnomah County has just been approved for phase 1 reopening. And while this is all happening, we're seeing additional spikes in confirmed COVID-19 cases and presumed cases, both in the state and also throughout the nation. So there are certainly fears that employees will have about returning to work, and this is really about, mitigating those fears, but also providing a safe work environment. 2 rules of thumb when we're thinking about bringing people back to work and doing it in a safe way. The first is to really think about a legitimate business justification for bringing people back to work. And for those who are in essential workforces, they've been working all along, that's not as important. But for those who have been working remotely and maybe you've been doing it really well and it's been productive, that justification for coming back to work is going to need to be, is really important, is going to need to be communicated to staff and to employees. And maybe that means, you've been doing it well away, but you need to do training and development, and that really needs to be done in the office. That's one way to look at it. Or maybe productivity hasn't been as good, and that can be pointed to as a justification, but something to definitely think about. Coupling the justification with safety communication is really key. So actually implementing certain safety protocols and then communicating that clearly to employees is really going to help kind of stifle some of the concerns about coming back to work and knowing that it's a safe place to come back to work. And there's really business considerations for this. One, certainly as COVID-19 continues and as we navigate this, there's liability associated with bringing employees back to work in an environment that's not safe. And so there's risk and exposure to consider there. I think Oregon is in a special session right now, and there's legislation being considered for creating liability exemptions for those employers that do follow state and federal guidelines on health and safety with respect to customers that are encountered and also employees. So we'll see where, if anywhere that goes. But it's important to really follow these protocols. And then 2, stress and anxiety that your employees have are going to breed inefficiency. And so to the extent that can be mitigated, that's really important as well. This presentation draws from, many resources. I've listed some here, OSHA, the World Health Organization, the Center for Disease Control and Prevention, the Oregon Health Authority, Oregon Governor's executive orders, and also OSHA, which isn't listed, but something we've also consulted in preparing this presentation. I would really encourage those out there, particularly those who are in HR, to make these government agency pages some favorite pages of yours and sign up for alerts, because if you look at this presentation a week from now, a month from now, it's probably going to be a little stale. These updates and recommendations are coming out on a weekly, daily basis. And as we learn more and more about coronavirus and how we can mitigate risks, they're constantly making updates. So I would definitely encourage you to continue to stay up to date as well. Let's go to the next slide. Okay, so step 1 for thinking about bringing back employees to the workplace, both CDC and OSHA recommends doing a risk assessment, both of your workplace itself, but also of the job responsibilities and job duties that any one individual in your employ might encounter. And so there's 3 main factors in making that assessment. You want to look at the industry type overall and the risks associated with the industry type. You want to look at the employee's contact and the regularity with which they come into contact of the general public within 6 feet. If there's distances that can maintain greater than 6 feet, that has some risk reduction to it. And then also you want to look at whether or not your employees are coming into repeated or extended contact with those who have presumed or confirmed cases of COVID-19. And so those are the 3 main factors that go into where you fall on this occupational risk pyramid created by OSHA. Some examples of where different industries and different professions might fall on this risk period. Very high risk positions are typically medical professionals and dentists, those performing laboratory procedures, those kind of items. Medium, where more medium risk is going to be occupations where you're regularly coming into contact with the public within 6 feet. And so that's identified typically as school settings or retail settings. And then your lower risk jobs are actually identified by OSHA as most jobs in the United States. And that does include most office jobs. And that's where you're not coming into regular contact with the general public, and most contact can be maintained at a 6 feet distance. And so you want to use this pyramid in, assessing, again, both the workplace itself and the individual tasks that any one employee might have. And you use that to then determine what PPE you might need, if any. I will say that OSHA recommends for those in the low risk category, they don't recommend any specific PPE for those positions, which might be surprising to some people. And but I put the link here that you can go to kind of compare your specific industry or your specific job with the recommended engineering and administrative controls. Let's go to the next slide. So best practices for reopening when it comes to employee screening. And we're going to kind of go through some different categories that are addressed by the risk assessment, but they're not necessarily specific to any industry. It's important to really hone in on your own industries. We'll talk about these more generally. So I should say that before diving into this. So first, just EEOC guidance on the ADA. I mean, if you had asked us at the beginning of the year as employment lawyers, could I dig into my employees' health records before they start the job every day and take their temperature, we would have said a resounding no, you can't do that. But of course, what's come out of this pandemic, and because we're in a pandemic with community spread, the EEOC has issued guidance saying that it is appropriate to perform health screenings before an employee starts their day as a way to ward off against the direct threat that COVID-19 in the office presents. And so that is permissible. Now, the EEOC has said, in terms of what type of tests are permissible versus other tests, it is impermissible for an employer to require a COVID-19 active viral test, it's not permissible for an employer to require an antibody test, at least at this time. And some of the reasons is just the unreliability of the antibody test and what we don't know still about what it means when you test positive for the antibody in terms of the duration of the benefit of that. And so that can't be used as a direct threat test or required by employers. Of course, it can be done voluntarily by employees. Some other things to think about when we're looking at screening and what screening should be chosen. You might think about if you're doing in-person screening versus remote health checks. Actually, OSHA just recently issued guidance last week that recommends that offices reopening rely on having employees do their own health screenings at home prior to coming into the office rather than taking temperatures at the workplace. So having employees take their own temperature at home and monitoring that on the home front. Temperature checks, something to consider. The CDC has put out guidance on how those logistically can be accomplished, either from a social distancing standpoint or relying entirely on PPE. So it kind of depends on the logistics of your office if this is something you choose to do. It is permissible. You also want to think about with temperature checks, what is the threshold we're setting for the temperature that's going to trigger a positive and trigger having the employee be sent home. The CDC recommends that's 100.4 degrees Fahrenheit. And then you also want to think about who is administering the test as well. You typically want the person administering the test to be someone either in HR used to handling confidential situations or sensitive situations, or you want it to be, if you're lucky enough, you could have a medical staff on site. That would be an appropriate person to kind of handle those tests and checks as well. We've covered kind of what testing is permissible, the active viral test versus the antibody test. It's important to keep in mind that with any screening and when you're gathering health information of your employees, those are really confidential health records. And so it's necessary that you not keep those records, to the extent you're collecting any data, in the employee's personnel file. It needs to be kept in a separate confidential area. And then,
yeah. Jennifer, we have a question on the testing part that I think might be good to cover now.
Sure.
This is a senior living employer, but I think this applies to lots of employers, which is what if the employee refuses to get tested? You require it and they refuse. Can you take disciplinary action for that?
Yeah, and so because of the EEOC's guidance saying that it is permissible for employers to require screening, because it does help assess whether or not that specific individual is a direct threat to the workplace. If someone refuses to take the test, you have the policy in place, you're applying it in a non-discriminatory fashion. So either across the board or to certain sectors that require the screening based on your safety protocols, and they refuse to take the test, then you can discipline for that. You can send them home there and determine what additional disciplinary measures or steps need to be taken. So another consideration is paying for this screening and paying for these tests. So it's important to keep in mind that if it's an employer required screening, you need to cover any sort of out-of-pocket expenses with that. So any copays with that need to be covered. You want to think too, if you're doing screening on site and that requires some wait time for purposes of screening, that's typically going to be compensable time that needs to be covered. And then if you have a policy in place that, let's say, I've heard this one come up a lot with regard to travel. You know, now employees are thinking about traveling out of state, both for fun and also for business reasons. And if you have a policy in place, for example, where you require a COVID-19 test after any out-of-state travel or any air travel for any reason, if you require any isolation period before getting that test, or if you require the test and they're waiting for the results or waiting to take that test, that's likely going to be covered paid time under the FFCRA. So Randy will talk about that more in a little bit. Let's go to the next slide. Okay, so PPE and masks. Masks are really a hot topic right now, particularly given the governor's new rule that came out this week. But first, let's just talk briefly about some other forms of PPE, gloves, gowns, surgical masks, N95. masks. This is all what the CDC recommends and identifies as actual PPE, personal protective equipment. Face coverings, just general cloth face coverings, aren't PPE. And so earlier when I said, lower risk workforces, they don't recommend specific PPE for, that is true, but that doesn't get into cloth face coverings. Typically, the N95 respirators aren't required for most office settings, or for any office settings really, or most workplaces, but it's important again to look at kind of your industry requirements there as well. The gloves and gowns, one thing I will say is even if you're in a lower risk work setting, if you are having employees that wouldn't otherwise be doing like cleaning, additional cleaning or enhanced cleaning responsibilities, you want to think about getting them gloves and gowns for purposes of doing those enhanced cleanings. That's something sometimes employers forget about. With the governor's new rule that went into place in Oregon, this affects, as most of you probably know, 7 counties in Oregon, and it requires face coverings for the defined indoor businesses, their employees, and their customers. And so businesses are defined as grocery stores, fitness-related organizations, pharmacies, public transit, personal service. And personal service always kind of gives me pause. What does she mean by personal service? Well, she went on to define that's hair salons, nail salons, non-medical massage parlors, tattoo parlors, barbershops, things like that. It also covers restaurants, bars, breweries, wineries, retail stores, shopping centers, malls, indoor swimming pools, and indoor spas and indoor sports courts. So it's not going to cover every business out there, but it does cover a lot of businesses, and it has this face mask, face shield, or face covering requirement for all employees and customers. There's some exceptions to this one. As with any good rule, there's an exception. Children 12 and under are exempt, but it is recommended for children ages 2 through 12 to wear the face coverings. Those that have medical conditions that would make it hard for them to breathe would also be an exception. And then also anybody with a disability that would prevent them from wearing the mask would be another exception. So let's say you're not one of the businesses that are going to be required to have these face coverings for the local rule. It's still important to think about whether or not face coverings make sense at your workplace. The CDC guidance is a strong recommendation for face coverings, even in office settings. But too, you can think about, well, what does my office setting look like, and how do people interact with each other in their office settings? If you're typically in offices or cubicles that are 6 feet apart from others, perhaps it doesn't make sense to wear the face coverings all day. You could think about, well, maybe I'm just going to require it when people are moving about the office or interfacing with each other. So that might also be an option. And with any PPE or the face coverings, it's important to provide training to your employees in terms of, how to put them on, donning and doffing the equipment, how to do that appropriately. And then also, is it single-use equipment? Does it need to be discarded? How do you discard it? Where do you safely discard it? And then also, is it going to be laundered? Who's going to launder it? Is it the employee's responsibility? Those are kind of some of the things that need to be addressed before you roll out PPE or face coverings. Let's go to the next slide.
And Jen, can I throw in, there was a question about temperature checking.
Sure.
And in this particular case, the employer has employees record their temperatures a couple times a day, and they log it on a sheet in the break room that other employees can see. So what do you suggest on that? What do you think about that?
Yeah, I think so. Again, any sort of medical data that you're collecting on employees, and that's including temperature reads, it's confidential information. So I wouldn't post that publicly anywhere, and I would keep it stored separately from the personnel file. Only the people really on a need-to-know basis should have access to that. So the person who's doing the screening or the supervisor who needs to make the call on sending the employee home, whoever that team is, it's identified on making those decisions. Okay, so Randy interrupted me with a question, which is totally fine, but this is where I was going to sing to you and give you a musical interlude. Don't stand so close to me. Everybody knows that, right? Okay, I'll spare you. Let's move to the next slide. All right, so social distancing. We hear this term thrown around quite a bit. First and foremost, it's really important to have an appointed social distancing officer for the office. This is a requirement from Governor Brown's order, but it's also a recommendation from the CDC and also OSHA. So it's important to appoint that person, and it's important that who that person is communicated to the staff so that everybody knows who that person is. To the extent OSHA is doing on-site checks or inspections, one of the first questions they're going to ask is, who is your social distancing officer? So it's really important that anybody they encounter knows who that person is. Another recommendation is to measure out 6 feet from where people are sitting or where people are regularly working, and use carpet tape or other markings to designate those areas so people have visual cues about where that 6 feet recommended space is. Also think about designating workflow in the office. So maybe one-way people traffic in the office so others aren't moving past each other unnecessarily. You might want to consider postponing non-essential meetings or larger gatherings, or even consider doing remote meetings even though you're back at the office. You may consider closing common areas like the break room, or limiting the number of people that can go into a common area at any one time, given how it's set up and structured. In terms of engineering controls, reconfiguring office space may be important, and moving cubicles around or other workspaces to create that distance that's required for continuous work. Think about eliminating touch points. So you might want to think about all the drawers and cabinets that are in common spaces that people open, and pull those open so those don't have to be touch points that need to be cleaned on a regular basis. Or think about opening doors that are typically closed so people don't have to be touching those handles. And then for positions where it's either maybe there's regular interaction with the public, or it's hard to maintain that 6-foot barrier, you should consider plexiglass barriers or other physical barriers to help prevent contamination and spread. Let's go to the next slide.
And hey, Jay, can I interrupt yet again? I know I never do this ever to you guys, but,
of course you can, Randy.
Couple questions real quick, and hopefully I'm not jumping to something you're going to cover. But we've had a couple questions about traveling. So folks that either it could be locally, travel or on a plane. And so what do we do in that case? And also just people who choose to take a vacation where they might be exposed to others. Is there anything in particular that you're recommending? Can we tell employees not to vacation or not to leave town? Can we require quarantining, that kind of thing? And I know you addressed this a little bit, but maybe hit that one more time.
Yeah, absolutely. So, I know this is hot for everybody because now it's summer and people have been in self-isolation, so they want to get out of their house, and they really want those vacations. So I think it really depends on what the employer feels comfortable with, and I think it's good. You want to pick kind of something that you can apply consistently, set a policy and then apply consistently to everybody, right? So maybe your threshold and your kind of increased risk is any air travel. So if anybody's going to air travel, do any sort of air travel, then because of that increased risk, you're going to require testing before return to work. That might be one approach. Another might be any out-of-state travel. Another might be any sort of travel for work where that's going to be required. So you want to pick kind of a measurable threshold for where you're going to require additional screening or additional return to work testing, and then consistently apply it to everybody at the workplace.
Okay, I got one more for you.
Okay.
So speaking of testing, so if someone tests positive, this is an awkward situation, right? Because we kind of want to tell everybody, but should we tell everybody? What do we say in those cases?
Right, that's a great question. So, the information of someone who has a positive test is also confidential health information. So, you really shouldn't be disclosing who that person is by name, but you do have some obligations in assessing who that person was exposed to at work and putting them on notice, putting those people who were in potential exposure threat on notice of the positive test. And then from there thinking about, okay, well, what was the interaction with that individual who tested positive? Was it prolonged? Was it within 6 feet? What was the extent of the risk? And then potentially recommending self-isolation for those individuals as well to stop that spread at the workplace. So there's a lot of, it kind of depends on the situation, but definitely you don't want to name the individual who has tested positive. Although, you know, your smart employees probably can, through deductive reasoning, come to their own conclusions about who that is. You don't want to be sharing that information. Okay, so this is more of the administrative controls that are recommended by OSHA and the CDC, and this is encouraging sick workers to stay home. So just a little review on symptoms. Typical symptoms of COVID-19 include fever, chills, cough, shortness of breath, difficulty breathing, fatigue, muscle ache, nausea, loss of taste or smell, sore throat, and congestion. And so if employees are experiencing any of these symptoms, we want them self-assessing, being very aware of those symptoms, and then reporting that to the supervisor and staying home. You know, that needs to be the message. If you're sick at all, you should really be staying home. If they are coming into the office and those symptoms develop, or if you're doing screening, daily screening at work, and you detect a symptom, and the key is really to isolate that employee and then get them to return home as soon as possible. And I think of the isolating tip, particularly if you're doing contactless or contact temperature checks. Sometimes there's some defects with those temperature reads, and so if you have someone who's throwing 100.4 or greater, you might want to isolate them and then recheck them just to make sure that that's an accurate read. But if you're going to do that, you really need to isolate them before sending them home and before confirming that read. And then to the extent that they are sick, I would recommend giving them the FFCRA leave form so you can properly document that and get any sort of tax credits or reimbursements that you're entitled to as an employer. And Randy's going to talk about that piece of it more a little later on. So
we're in allergy season right now, so we got lots of people sneezing and coughing and things like that. So that makes it even more challenging for employers, right? Right.
Yeah. I mean, you really have to educate employees so that they can kind of self-assess, because a lot of this, it's hard to know, is this just something they experience every year with allergies, or is this a new cough or sneeze, right? That's we need to be concerned about. So when thinking about your sick employees that you have sent home, they shouldn't be returning to work until they meet the criteria to discontinue home isolation. If you aren't using testing for purposes of getting the employee back to work, the rule of thumb from the CDC is that they're symptom-free for 3 days, and that's symptom-free without the use of fever reducers or other medications. And they are also at least 10 days removed from their first symptom. So that's kind of the general rule of thumb where testing isn't in play. Of course, and I haven't mentioned this yet, but of course there's also asymptomatic individuals, which is why it's so important to have all of these comprehensive safety protocols in place, because someone may not be exhibiting symptoms but could be a carrier and potentially contagious. So let's go to the next slide. Okay, so just real quickly here, just some other considerations and food for thought in thinking about developing a safe workplace. Enhanced cleanings, this both refers to kind of daily enhanced cleanings related to high touch points, but also if you're about to reopen, you might consider doing a deep cleaning. That can help allay some fears for employees when they're coming back to work. And then certainly if there's been an exposure at work, you want to think about following CDC guidance on the cleaning for that exposure area. If you are cleaning, you want to wait 24 hours before cleaning the area if possible, or wait as long as you can before cleaning the area. And then if it's been more than 7 days since an employee was was contagious and at the work site, there's no special cleaning required, but if it's been less than 7 days, the CDC does recommend a deep cleaning. And then certainly if you can, ventilating the exposure area is recommended. Definitely you want to post hygiene reminders in the bathrooms and in the where you post other posters about frequent hand washing, the duration and length of hand washing, minimal face touching, those guides. If you don't have readily available the ability to wash hands regularly, consider having at least 60% alcohol-based hand sanitizers, although I say that with a word of caution because I think the FDA just released a list of 9 hand sanitizers that have toxic levels in them that were manufactured in Mexico, including methanol and I think wood alcohol that can be toxic. So don't look at that list and don't pick those hand sanitizers and disseminate them to your employees. But that's also a recommendation where hand washing isn't readily available. You might consider upgrades to your HVAC system, including increasing ventilation rates. The CDC recommends getting your system as close to 24/7 system runs and disabling on-demand ventilation controls. Anything you can do to increase ventilation, either opening windows and doors is encouraged. You can eliminate or reduce in-office meetings and continue to use remote platforms for meetings even after you've returned to work. Adjusting shifts and schedules is something to consider. Some people do staggered shifts to reduce the body count in the office, or they do a 1 week on and 1 week off to get among different teams at the workplace to kind of help get that body count down at the place of work. And then it's good to eliminate or minimize the use of shared equipment. So think things like phones, computers, pens even. And then if you can't, to the extent you can't do that, to institute cleaning protocols between use so that people aren't sharing equipment without having cleaning in place. Also think about if it's been a while since your building's been open, safety checks for buildings, particularly including checking the water system, especially if it hasn't been occupied for a long time. And then you can minimize or discontinue non-essential business travel as well. Just some additional considerations.
And Jen, on that issue, we have lots and lots of questions on travel, and I'll kind of summarize the questions and my answer. So basically the questions are, hey, it's a little unfair that we have to pay for the test for the stupid employee who went somewhere and wasn't supposed to, and or, can we ask about how good were they at social distancing and what kind of travel did they do and all this kind of stuff. A lot of questions that if we weren't in the middle of a pandemic wouldn't be allowed or would be questionable. Right. I think you can have very, much more free to ask questions, to set up standards for what you consider to be appropriate travel and what's not. You can, I think you ought to give employees fair warning, but you say, look, if you're going to travel, and we're going to make you stay home for a few days. And, if you're allowing remote work, great, they can work remotely. But if they can't, if it's a job they have to be at, sorry, but you're going to be not working for a few days. And that's not going to be covered by unemployment because it's not, doesn't fit the criteria. But hey, that was the price for going on vacation. So that's kind of the gist of that. We should probably move on though.
Yeah, I would just say with whatever you decide, make sure you have a policy in place that you can kind of, it's not as subjective, it's more objective standards that you're applying, and then you consistently apply them to the individuals. But Randy's right, you do have more freedoms to do that. So let's go to the next slide. And this, I'm going to hand this over to David in a second because, you've got all these safety protocols in place. And then, you're feeling good about your workplace, it's safe, you're ready to bring your employees back. And then you get this question, do I really have to come back? And then you get the classic lawyer answer, it depends. And I'm going to turn it over to David to take it from here.
Good, thanks, Jen. So go ahead, we can start advancing some slides here. We've got a couple of issues to deal with. First is going to be leave issues, and Randy's going to cover a lot of those. I'll cover the ADA aspects, but then there's kind of two groups of employees, those who have returned to work and want to return to work. And I think we're all fortunate if we're opening back up and we have employees who want to return to work. But then what happens to the employees who don't want to return to work? And I think that's a little bit more problematic for most employers. So go ahead and advance the slide. Keep going. Yeah, there's a big question right now about whether handshakes will ever come back into the business community. So we'll see if that happens. First, though, the issue for employees who want to return to work. You know, we've been getting a lot of questions. So for those of you who haven't figured out the question feature here, I know a lot of us are used to Zoom, and this is Teams, so it's a little different. But there's a little pop-up when you scroll over your screen with a little box with a question mark. You can get your questions there. Your questions will not be published to everybody unless one of the presenters here publishes it to everybody. If we think it's a question that would benefit the rest of the group, then we'll publish it to everybody. But there are a lot of questions in the string where we are replying privately. So just so you know, feel free to ask more questions there. We're trying to get to everybody's questions, but there's quite a few over there. So you know, what are we going to do for employees who are symptomatic? And there's been a lot of questions on the Q&A about what happens for an employee who's symptomatic, and Jen covered this a lot. We can require them to stay home. Of course we can. We're going to say 72 hours after their symptoms have ceased. There's been a lot of questions on travel. The most recent guidance that we've seen is, you know, 4 days after they've traveled, they can get tested, and the test should come back. If it comes back positive, great, and we're eliminating the false negative that way. So get tested after 4 days. But we can require them to stay home if they're symptomatic, and that's okay. And that's just like in any other case. It's if you have an employee during the flu season who's clearly got the flu, you tell them to go home. That's okay. We're entitled to do that for the safety of our workforce. What about the employees who are complaining about lack of safety protocols? We're getting a lot of employers who are saying, well, I've got employees who want to return to work and they're here, but now they're complaining once they're here. We're not doing enough for them. Whether the employee wants to return or doesn't want to return, they're complaining about the lack of safety protocols. We should engage in a conversation with them. But we need to be very careful with these employees because they've obviously got potential whistleblower complaints and protection. So once employees start complaining about whether we're doing enough for them or not, whether they want to come back or not, engage with them, tell them, inform them what OSHA and CDC guidance is, and say how we're trying to comply with that guidance. If they've got questions, we've got a safety officer that's been assigned, a social distancing officer that's been assigned, and welcome to continue to address questions to those individuals. We want to have good dialogue with employees, obviously not confrontational. Hopefully they get on the same page with us. There are questions, so OSHA does allow employees to stay home, so this gets more into the second issue, but we do get employees who are allowed to stay home if we have an obvious issue of safety at the workplace. However, no court, no administrative law judge or any agency has said that COVID, even if you're a medical office treating positive COVID patients, have said that's enough for employees to be able to stay home. If you are working with individuals who are tested positive for COVID, that obviously opens up a whole separate issue, but just the mere risk of employees getting COVID is not enough under OSHA guidance for employees to be able to stay home. So what about employees who may be vulnerable otherwise? You know, think of somebody who's pregnant or somebody who's got severe asthma, but they want to return to work, and out of maybe misguided, potentially, desire to keep them safe, we tell them to stay home. They're not allowed to come to work. We're putting ourselves into a lot of jeopardy, legally speaking, by forcing somebody to stay home who wants to come to work when we've opened up our facility for everybody else. Because now we're treating them differently because of our perception of their disability or pregnancy or whatever the condition is. So if an employee wants to come to work, they're allowed to come to work. I haven't heard a lot of employers that have done this, but I know it's an issue from other lawyers in other parts of the country. So we want to treat them fairly, and we may be able to keep them home if there's enough of a direct threat to themselves or others for them to come to work. Obviously here it's for themselves. We may say that it's a direct threat to themselves, but we probably want some medical provider weigh in before we tell them they can't show up to work. Okay, go ahead to the next slide. All right, this is where most employers want to spend a lot of time on is, what about the people that don't want to show up? So, you know, the biggest issue that we heard, especially early on, and we'll hear it less after next month, is employees don't want to show up to work because they're getting paid more. A lot of employees who've been laid off are getting paid, you know, they're getting the federal subsidy of $600, and they're getting paid more to stay home than they would be coming to work for you. Now, that's great for them, but once we've got work, available work for them, we're supposed to report to the employment department that they have available work, and therefore they're not entitled to benefits. The employment department is really just a trustee of a fund that pays out employees who, in a certain situation when they don't have work, they are entitled to be paid. So if you have work available for them, they should not be getting UI benefits. Now, I know some employers who said, well, they can't come to work anyway. I don't want them to go out on EFMLA leave, which Randy's going to talk about later. You know, they're not going to get paid as much. I really care about this person. And so as a courtesy to them, I will keep them on UI benefits. You can do that. There's some risk with that, including the fact that they haven't even started drawing down on their EFMLA leave. And you've just left them on UI benefits, so they're going to get additional protected leave. And if you ever want to force them to come back to work, we're creating a bigger issue for ourselves. The next issue is the employee feels unsafe, but just doesn't have a medical condition or isn't even caring for somebody that's at high risk. So what do? Well, if they feel unsafe, we need to, again, investigate. We want to know why they don't feel safe, and we want to engage with them in a conversation about why they feel unsafe, and then go through the policies and protocols that we've put into place that tracks what OSHA, CDC, and other guidance for whatever industry you're in say that we should be doing. And once we've done that, we can tell them that they can come back to work. Again, OSHA has fairly narrowly defined when employees can't come to work because of fears for their safety. So bring them back, do what we can. I'm a little nervous about bringing some of these employees back, though. If they're going to complain, they may stir the pot a lot, and that's what a lot of employers are worried about, is those people becoming pot stirrers to the rest of the crew, raising questions that we think aren't very legitimate in terms of safety, but now everybody else is complaining about these same safety issues. So if that's the case, and they're continuing to raise these complaints for other individuals and themselves, not only do they have protections under OSHA, they potentially have Section 7 rights under the National Labor Relations Act. Now, most of you on this webinar are not unionized workforces, so you're saying, well, maybe the National Labor Relations Act doesn't apply to me, but for most of you it does. And because it does, when employees are complaining about trying to get a group of employees or group rights, they probably have rights under that statute as well. So we want to treat these people very carefully, and probably want to start talking to us before you make any termination decisions, especially on these employees, or take any other adverse action against the employees. All right. So employees that think they're being recalled because, and when others aren't, and that they're being recalled is discriminatory. So when you're only partially either opening up the office or you're only bringing a few people back from unemployment. Again, people like being on unemployment right now. And so they're saying, hey, you're forcing me back into the office where it's unsafe, and you're picking me over these other people, and I feel that it's discriminatory. Again, investigation is the best way to do things, but even better is before you decide if you're doing a partial return to work, making legitimate business decisions and writing those decisions down and how that decision-making process was done. You know, we're going to pick this group of employees because this group of employees is the most important to us, so we're bringing them back. And here are the people within that group that we are bringing back. So you want to make a detailed, rational analysis of what you're doing and why you're doing it. All right. So obviously there's some childcare issues, family medical leave, serious health condition issues that Randy's going to cover later for employees who don't want to return to work. So these aren't all the issues, these are just a few. But let's talk about some of the ADA issues on the next slide.
Yeah, and David, can I chime in real quick on the one thing that is coming up is sometimes you want to bring, you feel for the person who can't come back and you really don't need them anymore. But we've been doing some severance agreements when it's just not working out. The employee really can't come back, or they're afraid to come back. You're okay with that. You're okay with them getting unemployment. sometimes we can work something out with the employee, but you'd want to do a severance agreement for sure. But maybe they can, you indicate in your termination, this person was, terminated due to, layoff or lack of work or something like that, and then they can go after unemployment benefits. Certainly you want to do that per an agreement that was well documented. But anyway, that's been an option sometimes when we have kind of a tricky situation where we feel bad for the employee because we know that they really shouldn't and can't come back to work, but the doctor's not giving them a free pass and that kind of thing. So anyway, just sorry to interrupt, but just a little side.
And to piggyback off of what Randy is saying, keep in mind that at the end of October, the law changes in terms of what we can put into a severance agreement. And so if you have some dead weight that you're looking to offload, now may be the best and easiest time for you to be able to do it. And we can have a severance agreement where we've got more protections built into it than we can come October. Come October, and many of you have been to our seminars on this issue before, but come October, our rights related to what we can put into that agreement are limited. We can't get a no rehire provision, can't get a non-disparagement clause in there. So there's, and confidentiality may be limited too. So act now, I guess.
Yeah, and the beauty of the unemployment benefit right now is that it's very incentivizing. And so we've had cases where the employer didn't need to throw any extra money at the employee, just said, look, we won't contest unemployment, and you can be on unemployment with this extra $600 a month through near the end of July, and that was enough to get a severance agreement. So this is a good time for that, like David said, to trim some of the branches.
All right. So let's talk about some individuals with disabilities. And so keep in mind, this isn't a seminar on disabilities, and I'm already squeezing Randy out of time. So disabilities is really any mental or physical limitation that an employee has. I mean, the law is so broad that they had to specifically exclude eyeglasses in there. Otherwise, people that had glasses would be considered disabled under the law. So if you have employees who are asking for accommodations because of their disability, either mental or physical, then we need to at least consider those. And the EEOC has put out some very clear guidance about COVID. Even though COVID does not necessarily trigger their disability, and it could trigger their disability, we may have duties to accommodate those. Just examples of mental disabilities, and these are listed out by the EEOC, include anxiety. If somebody's, especially germaphobes or things like that, it may increase their anxiety. PTSD, OCD. If you've got a cleanliness OCD where you feel like you have to wash your hands, well, if you show up at work and you feel like you have to wash your hands 57 times a day because of your OCD, well, then maybe it's not reasonable for us to require them to return to work. Examples of other physical disabilities, heart issue, respiratory issues, immunocompromising conditions, things like that obviously are going to show up more commonly than the mental disabilities, and are much broader usually than the mental disabilities in terms of accommodation that we're going to have to give. So if somebody comes to you with a disability and say, hey, I've got an issue with whatever it is, asthma or something, and I can't return to work, or I don't want to return to work, or I need some special accommodation from you. First, we don't know more than their doctor. And that's going to be a refrain that Randy and I are both going to say, especially when it comes to leave issues. Oftentimes, we're just going to ask the doctor, what should we do? And when the doctor says they can go home, or they should stay at home, maybe we have to acquiesce to it. Maybe you're in a position, if you're a direct care staff person at a senior living facility, obviously work from home doesn't work, and maybe they're not qualified to do that job right now or maybe into the future. But if you can accommodate work from home options, that may be something you have to do. So the first thing we do is we want to ask the employee who has the disability, just like in any other disability situation, what do you want? Treat yourself like the Burger King cashier, right? How can I help you today? What do you want? What can I get for you? Then we have an understanding of what the employee wants, and we may ask for alternatives. Well, maybe that one won't work, but do you have any other ideas that may work? Well, let's talk about this. So then get the medical certification from the doctor. We can consider second opinions, and we can actually get them. We have to pay for them as employers, but every time, and I'm sure Randy and Jen will speak to this too, every time we get second opinions, they come back almost identical to the first, so they really aren't worth much weight.
They do more than good, yeah, usually.
Yeah. Yeah, it really just entrenches the employee that this is the accommodation that they actually need. Then we have to consider undue hardships. So an employer only has to give an accommodation so long as it doesn't create an undue hardship. If you've got an employee that says, hey, I've got a respiratory condition, you know, I'm working in a cube, but if you put me in an office and put in new special ventilation system and it's going to cost you $50,000 to do all this, that's probably not reasonable for most employers to do. Even Nike or Intel or somebody who's got tons of money, probably not reasonable for them to do that. We have to be careful when we cite economics as the role, as the reason for the undue hardship, because it opens up your financials in litigation. But the EEOC has expressed in their consideration, say, hey, look, in a post-COVID world, we have to understand that some budgets have been impacted. So even smaller amounts, even requests for accommodation that require smaller sums of money to fix may not be possible where they were before when the organization was either more profitable or just had more cash around to be able to accommodate employees. Then something that's as critical and most forgotten by employers is the follow-up. You know, once we've decided what the accommodation is, we've worked with the employee to figure it out, and we start working with the employee, we want to follow up on a regular basis. It's good to put something on your calendar to just say, hey, I need to follow up with Susie today to make sure that she's doing okay. And when she says that she's doing okay and the accommodation's working, make sure you're sending yourself or somebody else an email. You got it documented somewhere. So obviously, when in doubt, seek advice from legal counsel. So we're here to help.
All right, and I apologize, there's a little bit of background noise. I know I hear it, you guys probably hear it too, so I apologize. I'm not sure what that is. Maybe Jen and Dave, if you want to mute your mics, maybe that'll help. I don't think it's me, but who knows. Okay, so let's talk about all the acronyms. And so, you know, I'm a little bit older, and so, you know, the police, although the police is definitely my generation, MC Hammer, yeah, okay. But let's go back to the Beatles. So, you know, talking about leave law, we just need somebody to work, right? Isn't that the whole point? Come on, we need help around here. So who's going to help us work? So, so we've got, and it was interesting when this passed. It passed like, you know, kind of out of the blue, no regulations, no nothing, and we were all panicking trying to figure this out a few months ago. Since then, there's been a lot of guidance, and it's a little bit better understood, but still pretty confusing stuff. So let me go through the big picture on this. We don't have tons of time. We're probably going to go past the hour for those who want to stick around, but I'll keep this kind of condensed. So there's two kinds of, under the Families First Coronavirus Response Act, the FFCRA, there's two kinds of leave that were granted. There's the emergency paid sick leave, and there's the extended family leave. That's used for child, you know, care. Basically, your daycare is closed or the school's closed. So that's the big picture. Oregon kind of, they always have to sort of do their own little twist on things, and so they also, Oregon expanded Oregon Family Leave Act and expanded the use of sick child leave to also cover kids that the school or daycare is closed. So that also applies, and I'll explain how that works. Big picture on emergency paid sick leave is the employee gets their full wages for up to 80 hours. It's in addition to their family medical leave that they might have. And so it doesn't run concurrently with. So if they've used up all their family medical leave, they can still use this. This applies to all employers, by the way. I'll talk about a couple exceptions in a minute, but just about everybody's covered by it. But it's up to 80 hours for a variety of things, for school and daycare closures. Most importantly for this purpose is either to obtain a medical diagnosis related to COVID-19 symptoms, or if the doctor is advised to self-quarantine or to care for a family member whose doctor has advised to self-quarantine. Not somebody who feels like self-quarantining or just kind of wants to or really likes hanging out at home, but someone who actually has been told by a doctor. Good news is that it's paid for through an employment tax credit. So in the long run, it doesn't actually come out of your pocket. The other kind of FFCRA leave is the FMLA. It covers 2/3 of the wages, up to $200 per day. And by the way, on the 2/3 of the wages, you can use this. The EPSL can also be used for this EFMLA purpose, and they get 2/3 wages. So if someone, let's say they're not sick, but they just have childcare needs, they get 12 weeks. Part of it is EPSL, part of it is FMLA, if that makes any sense. So, but this is used only to the extent of the amount of FMLA leave they have on the books. The employee also has to have worked for you for 30 plus calendar days, and it's also paid for by an employment tax credit. The sick child leave is something that they can use available sick child leave for. It's not paid, but it's just another way one can use sick child leave if there's any sick child leave available on the books, which for most employees there probably is. Keep in mind this is only employers with 25 plus employees. Okay, next slide, Sarah. Okay, so what are the exceptions? And we thought there'd be a lot more exceptions than this, and it's been very strictly enforced. We're talking about 500 and less, fewer employees in companies that this law applies to. So healthcare employers, and you guys know who you are at this point in time, are exempt. And so you can offer these benefits to the extent you want to, and you can kind of craft it in the way you want as well. You've got some flexibility because you're not required to offer it at all. So you can offer parts of it, some of it, not all of it, that kind of thing. So there's much more flexibility. Small employers is where I thought we'd see a lot more easing up because small is under 50. Keep in mind that under the federal law, employers under 50 are not covered by FMLA at all. And so we thought that there'd be some more latitude here, but really it's pretty strict. You get to decide for yourself, at least for now, whether or not you're exempt under this small employer exemption. But keep in mind, you're going to have to prove that later if an employee ever sues you saying they weren't provided with this. So let's say you're a 15-person employer and you say, yes, we're not going to be, we're going to exempt ourselves from this. We hereby declare that to be the case. And 6 months from now, that employee sues you saying you should have given me time off to take care of the kids. I'll talk about the remedies, but you have liability there. So how does a business sort of declare that they're exempt from this? What are the bases? And there's 3 alternative bases. One is that providing the FMLA would exceed the available business revenues and cause the small business to cease operating at a minimal capacity. I think that's a little bit of a stretch because you're going to have to say that providing it to that particular employee will kind of threaten the viability of the business. Now, maybe if I had a coffee kiosk and I had 3 employees, I could argue that. But it's going to be a little rough for most employers out there to be able to argue that the business would be in jeopardy because 1, 2, 3 employees are going to be taking the FMLA. Another is that you're losing specialized skills. So you have a job that only this person knows how to do, and the business is going to go under if you can't do that job. That's going to be a rare case, I think. And then the other is that it's just you have a shortage of workers willing and able and qualified to do the job. And again, there's a lot of employees that probably still do the job other than the particular one who's asking for leave. So pretty high standard. Keep in mind also that the small employers are still subject to the EPSL. So there's no carve out for that. Everybody's got to do that no matter what size of a small employer you are. And then of course for the OFLA, even healthcare providers and even folks that are exempt under the FFCRA, they still have to provide the sick child leave for school and daycare closures unpaid if they have at least 25 employees. So complicated stuff. Sarah, let's see the next slide. Okay, so what are the penalties? The good thing is, what little silver lining there is here, the good thing is that employers who are not subject to FMLA, so they're under 50, there's no, you can't get sued for messing this up, but DOL can go after you, and it has been. There's been quite a few enforcement actions already, but typically, at least so far, DOL, the Department of Labor, is only going after back wages. I think I've seen a couple cases where there was liquidated damages in addition, but right now the law is so new, I think Department of Labor is mainly just going after back wages for employees who didn't get the leave that they were entitled to. But for other employers, so anybody who's bigger than that, if you violate the EFMLA, you have all the FMLA remedies, which there are many. So back pay, so what you, when you should have paid them, front pay what you would have paid them if they're still working for you, emotional distress, which can be scary, punitive liquidated damages, which is double their back pay, attorney fees, yada, yada. So violation of the EPSL, same thing, there's back pay, liquidated damages, attorney fees. The Department of Labor can also go after you for similar kinds of remedies, and there can be personal liability for supervisors that make bad decisions, and even criminal charges if you completely decide to not only not comply, but kind of flaunt the law. So I think that'll be rare, but still potential remedy. So bad things can happen. You have to post a poster. Probably most of you have seen this and hopefully have it posted already. If you have remote workers, you need to show that you sent that poster to your remote workers. This is available online. Just Google FFCRA poster and you'll have it. Okay, next slide. Okay, we have a one thing that you need for the tax credit is you need some basic information, and so you have to get some information from the employee, or the IRS is not going to give you the tax credit, which is kind of spoils the whole fun of this thing if there's any fun in it to start with. So we have a form. Send me an email if you want a copy of it, and it has the questions that you need to have answered so that you can prove to the IRS that you asked the right questions and had the right information. Without this kind of information, there's a chance the IRS won't honor that tax credit. Originally, we thought we could get lots and lots of documentation from employees, but Department of Labor has said no, we kind of have to take the employee's word for it. So whatever they tell us. So in particular, did a doctor order you to quarantine is going to be the big question usually. And if they say yes, we can't require the employee to provide a doctor's note. So important fact. So don't deny a request based on lack of documentation. Just get this basic information from the employee. All right, next slide. Oh, and by the way, there's lots and lots of information. Originally, when this law was passed, like I said, we had nothing, and so we were kind of making it up as we go along. And so, unfortunately, I think we're right, mostly, and so that's always comforting as a lawyer to see that you were actually right in guessing what the law would be. But since then, we've got 93 FAQs and counting. They keep adding new ones just on the FFCRA. So Google search those two searches and you can find lots more from the IRS and the DOL about this. But I wanted to cover a few scenarios that we've been seeing a lot of. So, okay, one is that your employee just doesn't want to come in. They're worried about getting sick. There is no emergency paid sick leave for the fear of getting sick, only for the actually getting sick or the being tested for the symptoms. So being not being sick and being worried about being sick is not covered. So that one's kind of easy. So if you do allow employees to stay home out of fear of being sick, you're not going to get the tax credit if you pay them. If they use their paid leave, you don't get any tax credit benefits from that. You certainly could allow them to do so or set up remote work, but you don't have any EPSL. Okay, employee was just fine teleworking, did a great job. You've reopened the office and you're bringing the employee back, and now they're saying, well, wait a second, I could watch my kids when I was at home, and I could do work and watch them, but now that I'm at work, I can't watch the kids anymore, and they don't have school and they don't have daycare. Well, then they can get the EFMLA. We have to give that to them, and so they'd get to stay home. So in that situation, I'd suggest why don't we have them continue to remote work? That would be the best solution. All right, next one. Okay, so what if a remote worker gets sick or they have intermittent childcare issues? Let's say the spouse is home certain days, or there's certain times of the day that they can't work, that kind of thing. They can use the EFMLA for the intermittent childcare issues, and they can even do that for if they're not remote working. If they're working on site, they could use EFMLA for intermittently. You have to agree to that. It's not a right they have. A remote worker who gets sick working remotely shouldn't be working. They should be recovering, so they're entitled to EPSL for that. But you don't get to have intermittent EPSL leave for someone who's working on site, because if they're sick enough for EPSL, they shouldn't be anywhere near you. They should be home and or getting tested. Okay, next one. What if the employer wants the employee to use up PTO? So they have a massive bank of PTO. They're going to be gone for quite a while. If it's EPSL, they don't, we can't force them to use PTO as in addition to the paid time off that's available to them. But under EFMLA, we can require that they use up their PTO for the school and daycare closures, and we get the tax credit. So we're having them use the PTO. We're going to be paying them full wages, of course, but 2/3 of that paid, 2/3 of what we're paying them is paid for by Uncle Sam. So, yay for us. Okay, next slide. Okay, so let's say you do a layoff, and this was, I must have had 20 questions on this back in, I don't know what it was, seems like a year ago, but it was probably just late March on this because we didn't know the answer to this. Fortunately, this has been a good thing for employers. If you're doing a layoff or if you're reducing work hours, there's no FFCRA leave available. It's all about working and whether they can work or not. But if you don't have work for them, FFCRA does not apply. So that's both types of leave. What about the employee? Let's say they use the 80 hours of the emergency paid sick leave, and then something happens later in the year. They get a relapse, or there's some other reason. They now have, they're caring for someone who has COVID, something like that. All they get is the 80 hours through the end of the year. They don't get anything more than that. So once they've used that up, there's no more paid leave available to them under the FFCRA. Okay, next question. They've used up FMLA for something else. Let's say they had a serious health condition, they had a surgery or something like that, and they just don't have any leave available, or they have very little leave. Can they use EFMLA for the school and daycare closures? And the answer is only to the extent that they have leave still available. They don't get any extra leave. They can only use their bank of leave that they have available. Again, that's not true for the emergency paid sick leave. All right, next question. Okay, pregnancy. This gets really complicated, and I've had a couple of these last week or so. Let's say mom is pregnant and goes out on pregnancy disability leave to have baby, and then takes parental leave with baby. Is any of that covered by the FFCRA? And the answer is no. Okay, but if the employee has other kids that have daycare closed or their schools closed, they could take the EFMLA to watch those kids. They just don't get the EFMLA for their own pregnancy or parental leave. Now, we had a situation come up where the employee couldn't find childcare for the new baby. And I think in that case, it's probably not, the employee's probably not eligible for EFMLA because it only applies when the person's provider is closed. And so assuming that the parents did not get daycare arranged, and now after having the baby, they're looking for daycare, that's not really the situation that applies here. The situation is your established provider closes or is not available. That's when you get it. So kind of a little twist there. And there's lots more, so much fun reading on the FAQs. So I hope you all visit those FAQs and check them out. All right. So we've got, we're going to stay on the line for questions. And David and Jennifer, have you been looking at questions? And is there anything we want to approach right now?
I think we've got them, but one of the points that I was going to make to follow up on childcare is here in Oregon, we've got DHS who's given guidance to the daycare divisions, been telling all the daycares what to do, and they are not phase driven at all. So we're going to have a lot more employers reopening, but daycare providers are still very limited in how many kids they can provide service to. Still have to give priority to first responders and medical providers before anybody else. So you're going to see a lot more challenges with employees with small children and getting back to work.
Agreed. All right, any other, let's see, we have a couple questions. Just looking through these real quick. Anything that we want to respond to here that we haven't covered yet?
I saw one just recently come in related to, now that school's out, what does that mean in terms of requiring employees to come back? I mean, thinking about summertime, already there wasn't school, in a normal summer. So what happens now when they're saying, I can't come in because I've got these childcare issues? And I think the answer to that is it really depends on whether or not they have a true inability for childcare, right? Regardless of whether that's school related or other forms of childcare.
Yeah. Yeah, sorry, I was reading another question, so I apologize, Jen. So a little.
Here, I'll take that one. So
yeah, thanks, David.
So obviously, the EFMLA still will apply to individuals just because school is closed. If they can't find childcare for their kids otherwise during the summer, if you have, kindergarten, first grader, second grader, they can't stay home alone. And even, older teens, they can still take EFMLA leave during the summertime if they haven't exhausted it. Once they've exhausted that leave, then we've got a lot more flexibility in how we can treat those employees. But until that leave is exhausted, we want to make sure that they are getting the leave. There was a question about, well, can we require them to come back once a week while school is out? Well, if they're on leave, we can't require them to come back. If we're having them stay home and they're working while their kids are there, maybe there's some flexibility, but if we try to force the issue, the employee may try to take EFMLA leave. So kind of a tightrope for that one.
Good. Okay. Well, I think what we're going to do is we'll stay on for a couple more minutes to kind of see if there's any other questions. We'll probably respond to those through a private message rather than audio. So, but we'll hang on that. And thanks for everybody for attending. We really appreciate it. We're looking forward to seeing everybody face to face someday soon. Don't know when, but hopefully soon.
Thanks everyone. Good to be here.